Good afternoon. My name is Maciej Janka. I am very proud and happy to welcome you here to the base of Jagiellonian University on the official opening ceremony of the ICC comprehensive course on arbitration training. This is a great privilege and joy for me because this course is organized by three entities which are very different. I am proud alumni of the Jagiellonian University, and I actually owe this institution a big deal. I am former president of ICC Poland, and this institution is very important for me as well. And right now I am Polish representative in the ICC Arbitration Court as a court member. In addition to that, I am practicing lawyer as a counsel and arbitrator, focusing on arbitration. So now you understand what I'm doing here and why I'm co-chair of this arbitration course. And let me introduce my co-chair of this arbitration.
Good afternoon or good evening. My name is Arbitration. It's my great friend has just told you. And I'm privileged to represent the Jagiellonian University as a co-chair of this course. It's a great pleasure for me. And I won't be talking a lot about myself because this course is not about me. I will just reduce this initial phase of my speech to declaring that I'm in love with arbitration at least since 2009 when I had the pleasure to be a member of the Bismuth team here at the Jagiellonian University in Krakow. Immediately afterwards, in 2010, I have completed my master thesis on arbitration agreements, and it was the beginning of my adventure as a scholar here at the Jagiellonian University. That thesis was an opening the door for me to continue my education, a doctoral program, a PhD program here, and afterwards to become a scholar, young scholar, also here at the chair of civil procedure. So, as I said, for me to be able to contribute to the development of the practice and fine art of arbitration here in Krakow and here in Poland, it's a great pleasure. It's a humbling experience, and I really hope to contribute to that aim of developing the practice of arbitration in Krakow, in Poland, and in this part of Europe. So yes.
Let me say a couple of words about the organizers of this event, this course. Let me start from ICC. Probably all of you know that ICC is International Chamber of Commerce, but we should realize that this is the biggest and the oldest business institution, business organization in the world. It was established in 1990 by a group of French entrepreneurs who believed at that time, and it was immediately after the Second World War, that cooperation and trade between the nations will enable them to preclude or to support that the war will never again come back. And we can now realize that this goal is still to be achieved. But during that time, ICC as an institution introduced or contributed a lot to international trade. It's enough to say that, for example, the Incoterms, which are standard terms of the trade, international trade, is something what ICC introduced. In 1923, ICC established ICC Court of International Arbitration. And this is still the biggest institution, arbitration institution in the world. But this is not about the size. What is really important is that ICC is really truly international arbitration court. Why is that? It is connected with the fact, with the structure of ICC as such. ICC members are national committees. ICC Poland is the Polish National Committee. We have the privilege of having it here today. Cezary Wiśniewski, who is president of ICC Poland, and we hope he will say a bit more about ICC Poland. But the fact that ICC consists of national committees is not only found on the top of the structure, but has direct impact on everyday activity of arbitration court. For example, myself, I am delegate of Polish National Committee to ICC in Paris, and I work constantly with the arbitration court. For those of you who will be participants of our course, you will learn that in details, how international ICC is and in which way national committees contribute to the arbitration procedure.
Let me tell you a few words about Jagiellonian University in Krakow. Some of these issues may sound like cliches, especially for those of you who are from here, from Krakow, or from Poland at large. However, let me start with a more subjective element. Actually, I may tell that, Jagiellonian University is part of me, because I'm attached to this university since 2005. So it's already a lot of years of my life, and at the same time, I'm also a part of this university. So this is a very subjective, very personal experience of being part of this great university. But as you well know, Jagiellonian University is actually a very cradle of science in Poland. Yes, it's the first university established in 1364. So one can say that actually it's the past, the present, but also I'm very much confident about that future of very important part of future of science in Poland. Thanks to all of those who work in this university, who contribute, who are passionate about developing, teaching, research, and so on. What Jagiellonian University means in numbers as of now, it's more than 37,000 students as for now, according to official data. It's almost 9,000 employees, including circa 5,000 academic teachers and researchers working for the Jagiellonian University. It's 16 faculties, including the Faculty of Law and Administration, that is a law school of the Jagiellonian University. I won't be talking about that as our guest today is Vice Dean Professor Kowalski, who I'm sure will tell a few words about our Faculty of Law and Administration. And finally, it's 166 fields of study. So I think that these numbers tell a lot about where we are, how important, what is the scale of day-to-day operations of this university. But Jagiellonian University is definitely much more than that. It's also a state-of-the-art infrastructure. We are in one of the buildings owned by the Faculty of Law and Administration. These are also large-scale projects run by the Jagiellonian University, including the Jagiellonian Center for Experimental Therapeutics, Małopolski Center for Biotechnology Omicron, and National Synchrotron Radiation Center Solaris, truly state-of-the-art research installations which allow this university to contribute to the science and development on a European and also, I would say that, a world level. Jagiellonian University is also about strong day-to-day collaboration with major academic centers from all over the world, including membership in prestigious Europa Alliance of 11 European universities, sharing a new vision for the university of the future. So this is who we are, and I'm really proud to be a little part of this great place, this great institution. So it's all about the parties who together decided to establish this great program. And now we will move on to a short presentation of the very program, yes, of the program that we inaugurate today. So as you can see, what is exceptional about our program? Of course, everybody could tell that the program that he participated in developing and operating is exceptional, but actually I'm truly convinced that our program has these features that can support and corroborate this statement that our program is truly not only valuable but also in some instances exceptional. So yeah, the most important part of our program is a practical approach to teaching international arbitration in accordance with the best standards, up to date, developed and supervised by ICC. The participation of ICC, of Polish National Committee, of ICC, the active participation, including in developing the very program that is the case in thought, materials on which our participants will work. All of these allow to state that these words that you can see is not just boasting about something that is on paper. Additionally, our program includes 16 top-tier arbitration practitioners from all over Europe, not only from Poland, who will teach and give their instructions to our participants. Indeed, I can tell that thanks to the cooperation with ICC, IC Poland, the pool of arbitration stars who will provide their instructions is quite remarkable. What I think, from my perspective, is quite special is this special mix of experiences and practical skills given at the same time, the same day, by two distinctive scholars and practitioners from different parts of Europe. So I think that this is really something that allow us to have the confidence that our program is truly worth participating in. Of course, Krakow. I don't want to give any cliche, but anyone who knows this place usually very easily falls in love. It may be a love from the first sight. And I think that, yes, being here just few steps from the World Heritage Historic Center of Krakow is also something worth experiencing during our course. From those of you who are from Krakow, it's an opportunity to discover Krakow once again from a different perspective. From others, it's an opportunity to start this romance with my city, my best place in the world. Yeah. I think we can move on unless my great friend would like to add something about our program before we move on to inviting and presenting our great speakers and participants today.
I just wanted to add one thing. When we are preparing this course, our purpose was to find out what will be the best for our students. And what we really thought what is invaluable is the direct personal contact with the best arbitrators in Europe. You will have a chance to spend with those people not 15 minutes, not an hour, the entire day. And we selected those people from the pool of the best arbitrators in Europe, Western Europe. So from our region, from Poland, best arbitrators in Poland, and from the region. In order for you, our participants, to have the ability to ask the questions which you may think will be helpful to develop. Before we will go further, I would like to make also the point. Today's ceremony is an important point for us. It is official opening of the course, but still the registration protocols is still open until 11. So for those of you who are listening us in the internet, you can be still enrolled for the course. And then real course, first lecture starts on 26th. But today marks an important period during preparation of this course. And I think that it is appropriate, and I would like to do that, to thank people who had that happen. And from that perspective, I would start from Professor Jerzy Pisiul-Suliński, who was a dean of Warsaw Jagiellonian University Faculty of Law. And without his help, support, and emotions contributed to that project definitely would have not happened. I would also thank our assistants who were helping us to set it all up. And this is honestly complicated events. This is Maria Kuszczyńska and Rafał Wieczerny. I would also like to thank ICC. And starting from the top, I think that without personal involvement and supporting critical moments of Claudia Salomon, president of ICC Arbitration Court, that would not be possible. Alexander Fesas, who is Secretary General of the ICC Court, also was our supporter. And Ursula Mizraev, who is a person responsible for the continuing education and educational efforts of ICC, was also our supporter. And last but not least, I would like to thank the entire ICC Poland with Cezary Wiśniewski as the president of this organization. Thank you, all of you, and I hope that you will enjoy this course with us, seeing a lot of young people learning about arbitration.
Well, the list of persons that we truly owe our sincere thanks would not be complete without mentioning a new dean of the Faculty of Law and Administration, that is Professor Piotr Dobosz, who has provided us with a continuing support. I would really like to extend my gratitude for that to the Dean Professor Piotr Dobosz, and thankfully today with us is present Professor Michał Wiśniewski, Michał Kowalski. I'm very sorry for this mistake. Vice Dean of the Faculty of Law and Administration, actually responsible for international cooperation. So Professor Michał Wiśniewski, Vice Dean, will represent the current authorities of the Faculty of Law and Administration. I think there could be no better person than Dean responsible for international cooperation. Let me say a few words about Professor before I will invite him to to join us. Professor Kowalski is a truly acclaimed expert in public international law, in particular in the area of human rights. He's also head of the doctoral program in legal science at the Jagiellonian University, Doctoral School of Social Sciences. He's also not only a great scholar, but also person engaged in the broad practice of law. He's a conciliator at the OSCE Court of Conciliation and Arbitration in Geneva. He's an active member of the International Law Association's International Committee on the use of force and military assistance on request. He's a former judge ad hoc in the European Court of Human Rights. As an accomplished scholar, he's a former fellow at such distinct academic institutions as Alexander von Humboldt Stiftung, Max Planck Gesellschaft, and also the Tokyo Foundation. Let me welcome Professor Michał Kowalski, our dean.
Professor Kowalski for such a kind introduction. Ladies and gentlemen, dear colleagues, on behalf of Professor Kowalski, the Dean of the new Dean of the Jagiellonian University Faculty of Law Administration, I would like to cordially welcome all of you here at the Jagiellonian University in general and to our law faculty in particular. But let me say this, that I have to confess that I'm feeling a bit unbiased right now while welcoming you when I see in front of me Professor Jerzy Swiński, the former dean of the faculty, and let me say the face of the faculty and the good spirit of the faculty for long 8 years. And we could hear Professor Pisolinski greatly supported the initiative of this training program. So I'd like to thank you, Professor Pisolinski. Thank you for that, and thank you. We are happy you are here with us today. Also, I would like to emphasize that the new faculty authorities would like to continue or the policy, or even make it more effective, the policy of cooperation with practicing lawyers. We are absolutely sure that university legal education is much more effective if supported by practical approaches and practical experience. At the same time, many practicing lawyers, especially at early stages of their careers, may still benefit from trainings and programs organized by experienced academics, our faculty colleagues, and many of them having themselves vast practical experience in practicing law. So we are really very, as a new faculty authorities, we are really very proud of this initiative, and I would like to thank Professor Olaf, and I would like to thank the ICC Poland and the ICC and Mr. Janka for organizing jointly this training program. But let me also say that I'm a public international lawyer, so obviously I tend to look at arbitration through the perspective of interstate arbitration and its great legacy in public international law. And I think this is the right moment. It's worth recalling just here in this place that the Secretary General of the Permanent Court of Arbitration from 2022 is our faculty colleague, Professor
Professor Marcin Czepel. And also when we look at modern approaches to arbitration in public international law, I think it's quite illustrative to look at the evolution of the Permanent Court of Arbitration. Of course, we know that the name is quite misleading, but when we look at this development, we see that there are now only 6 interstate arbitrations pending under the auspices of the PCA. And there are almost 100 arbitrations arising under bilateral or multilateral investment treaties or national investment rules. And there are even more arbitrations under the PCA auspices arising under contracts involving a state or other public entity. So I think this is quite significant, this shift from interstate arbitration to investor-state arbitration. But being it interstate arbitration, being it investor-state arbitration, or I would say the most popular international commercial arbitration, I think there is no doubt that arbitration remains a viable dispute resolution option and is becoming increasingly important. And I'm pretty sure that the ICC comprehensive training on arbitration practice will benefit to the knowledge of arbitration as a method of effective resolving disputes in international business. So I wish you all very successful training. Thank you very much.
Thank you. I think that you referred that arbitration is preferable tool of resolving disputes in international relations, and I think actually that this is the only one method of resolving disputes if you like to find an independent forum for the dispute between entities from different states. Really, there is no other way. If you don't want to end up in the court of the party being party to the dispute, then you have to go to international arbitration. And this is a major strength and importance of international. But at this point, I would like to ask our supporter and our colleague, Dr. Cezary Wiśniewski, President of ICC Poland, to say a couple of words to us. Let me tell, before I will let him into the microphone, that he is a leading arbitration figure in Poland. Dr. Wiśniewski is a partner at Linklater, senior partner at Linklater. And nothing tells more about a lawyer, practicing lawyer, than the cases, the track record. And that is impressive. At least in 4 instances, Cezary represented the Republic of Poland in the major international disputes connected with the protection of investment. Cezary, please.
Thank you very much. Actually, good afternoon, everybody. There are so many kind, nice words that I'm almost speechless. So I don't know much or not to say a few words. So first, it's my really distinct pleasure to welcome you on behalf of the Polish National Committee by ICC to this training organized jointly by the Jagiellonian University and Court of Arbitration of International Chamber of Commerce. I truly believe that it's a really historic collaboration. And I'm saying that not without any Krakow roots, as just Maciej mentioned. I was born in Warsaw, I studied in Warsaw, I graduated from Warsaw University. I've been attached to the Warsaw University now for more than 40 years, but I still believe that the Jagiellonian University, with more than 600 years of experience in developing knowledge, in developing standards, maintaining skill to produce leaders and thinkers who shape our work, is probably best place to organize events like this. On the other hand, the ICC Court of Arbitration, as Maciej already says, is globally renowned for its rules, practices, and upholding the highest standards on fairness and neutrality. So just these features which are mostly seeked out by the users of arbitration. I don't want to steal your time by elaborating a lot about Polish National Committee at ICC. I think there's going to be time for that. I would like to share my personal remarks, two messages to our participants and to all of you, based on my own experience and my own practice. So, firstly, arbitration, international arbitration, is definitely at the forefront of dispute resolution in the global world. It's a very useful, extremely useful legal instrument, but I also truly believe that there is a deeper meaning, that there is a depth in this, which means that arbitration is a part of a culture, civilization based on amicable resolution of disputes. That's not only a legal instrument, that's not another interesting instrument of lawyers. It has its deeper meaning, and especially now we know that there is an alternative to amicable dispute resolution. It's a not amicable dispute resolution, which results we can see at the country's level, we can see it also at the entities level, and also among people. So I think it's important for all the participants to have this feeling that they participate in something which has its mission, its deeper meaning. And second thought I would like to share is about people. So over the course of this training, you will have the opportunity to learn from distinguished academics and practitioners. And please remember, arbitration is all about people and all about trust. So it's not like a common court, state court, where the parties, they don't have a choice. If they have a dispute, they go to a court, and that's not like an expression of their free will. And the arbitration is. And to create this fundament of this amicable resolution of disputes, there has to be trust. So the people, they have to trust their counsels, the counsels have to trust the arbitrators, and there has to be trust among the arbitrators. Without trust, without this, it cannot happen. And to know people, to get to know people, is an element which makes it possible. So people and this mission, I think that this is something we can really cause that people involved in this undertaking will do it with passion, because passion is also extremely important to do things up to our and the outside world expectations. So I don't want to steal much more of your time. So at the end, let me say big thank you to all who contributed to this program. Determination, Maciej Janka, Professor Oleś, Professor Suliński, the law faculty of the Jagiellonian University, all people who contributed to this. So let's embark on this fascinating, I hope, educational journey, and I wish all who are going to participate an enlightening experience. So thank you very much and good luck.
Thank you, Stefan. At the beginning of this conference, I alluded to the fact that ICC is a truly international institution. The former president of ICC Arbitration Court was a Brit, and the Secretary General was an Italian. Actually, that person in Antwerp is the our speaker. Right now, the president of Arbitration Court is an American, Gianni Salomon, and the Secretary General is Greek, Alexander Vesas. Alexander was supposed to join us today, but for the very important reasons who is unable to be with us today. But he recorded for us a special greetings, and we would like you to hear that. Please.
Greetings, everyone. My name is Alexander Fassas, and I'm the Secretary General of the ICC International Court of Arbitration and Director of ICC Dispute Resolution Services. It is truly an honor to address you today at this opening ceremony of the ICC Comprehensive Training on Arbitration Practice, a program started many years ago at the initiative of my former ICC colleague, Andrea Hauser, with the support of ICC Poland and a host of other colleagues on the ground. I would first like to take a moment to acknowledge those who have rekindled that program and thank the individuals who were instrumental in bringing it back to life. Special thanks to Maciej Szramka, ICC court member, and Malgorzata Surtek-Janicka, ICC court vice president, as well as Andrzej Olas from the Faculty of Law of the Jagiellonian University. Without their invaluable contributions, under the auspices of the ever-present ICC Poland, this initiative would not have been possible. Again, a warm thank you from all of us at ICC to all of them. As we look ahead to the coming weeks, I can confidently say that these lectures will be an enriching journey for all participants. Not only will you gain deep knowledge of arbitration as a powerful tool for resolving disputes in international business, but you will also develop and sharpen the practical skills necessary for understanding and eventually participating in international arbitration proceedings, particularly those conducted in accordance with the ICC arbitration rules of 2021. We relied on our much valued colleagues at ICC Poland and the esteemed Jagiellonian University to organize this very important project for us here at ICC. This comprehensive training on arbitration practice is a significant milestone for us. It represents a commitment to fostering the next generation of arbitration professionals in a manner that is both globally relevant and regionally specific. ICC has developed and implemented trainings for different audiences. These audiences include, on the one hand, business and in-house counsel who want to take an informed decision when choosing dispute resolution mechanisms, to people who want to make their first steps in arbitration, and also to experienced arbitration practitioners who want to become arbitrators or refine their understanding of the ICC rules, and also to those who are already practicing as arbitrators and who want to sharpen their skills further. Now, this program in Krakow marks one of the pilot projects that ICC is conducting, aims to develop the capacity of junior lawyers in arbitration on a more local level, tailored to the specific needs of a region while keeping a global scope. In line with the ICC Court's pledge to provide training and capacity building to strengthen dispute infrastructure globally, we plan to expand this program to other regions as well. I started working in arbitration at ICC in 2011 when I took the job of Deputy Counsel at the ICC Court Secretariat. But the history of arbitration, of course, stretches back to ancient Greece, my home country, and Rome, and continued through medieval Europe into modern times. ICC's story and its influence on present-day commercial arbitration started 105 years ago. In 1919, after the devastation of World War I, a group of visionary entrepreneurs known as the Merchants of Peace founded the International Chamber of Commerce. They fervently believed that fostering strong, mutually beneficial ties among nations through trade, industry and commerce would not only enhance prosperity, but also make them less likely to go to war and reduce the likelihood of conflict. The ICC International Court of Arbitration was established just 4 years later, in 1923, in response to the growing need for an international dispute resolution mechanism that could address the complexities of global trade and investment. From the outset, ICC recognized that justice is not only essential for commerce, but also a crucial tool for maintaining peace between nations. Over the years, ICC has been at the forefront of developing many of the fundamental principles that underpin international commercial arbitration today. To give but a few examples, from the creation of the 1923 Geneva Protocol on Arbitration Agreements to the 1927 Geneva Convention on the Enforcement of Arbitral Awards, and later on, what came to be the 1958 New York Convention on Recognition and Enforcement of Foreign Arbitral Awards, ICC has played a pivotal role in shaping the legal framework that supports arbitration today. It goes without saying that we are incredibly proud of this legacy and those who have contributed to it. Today, the ICC Court is a globally trusted institution for resolving cross-border disputes, boasting over 100 years of history and a broad geographic and industry presence. Our neutrality and deep understanding of the needs of international business make us the preferred choice for companies worldwide when they face commercial or primary disputes. By studying history, we also learn the lessons of the future, and I cannot emphasize that enough. And as the course of history moves sometimes upward and other times downward, and always in a spiral, it tends to repeat certain patterns. Thus, we find ourselves yet again at a time of tension, if not turmoil, in international relations. The world is in a state of geopolitical and economic turbulence, with a rise in armed conflict, trade wars, sanctions, and protectionist policies. The current global situation has created an environment of uncertainty and risk, particularly in international trade and investment. This state of global affairs poses a serious threat to the rule of law and to the access to justice. In times like these, the role of arbitration becomes even more critical. Arbitration has evolved beyond merely resolving standard commercial disputes. It now serves as a vital, neutral mechanism for managing risk and conflict in a world marred by tension and crisis. Its neutrality, flexibility, and adaptability make it an indispensable tool for ensuring that parties can continue to resolve their disputes in a fair and efficient manner, even in challenging times. Arbitration works two very simple words, but they carry profound meaning. In an increasingly globalized world, we need a stable, neutral forum that can stand above the shifting political landscape. Arbitration is, therefore, connecting businesses globally and providing a level playing field for all. This is especially critical when national courts may be perceived as the least better option for whatever reason. As the world's largest business organization, ICC is committed to promoting open trade. And while international business relationships are being tested, arbitration continues to enable businesses to enforce contracts and protect their investments across borders. By offering a neutral venue for parties from different legal, cultural, and economic backgrounds, arbitration fosters trust and ensures that international commerce can thrive even in a fragmented world. During the course of history, arbitration has resisted many challenges, which means that arbitration is here to stay. Dear colleagues and friends, your interest and dedication to follow this course proves the importance of arbitration and the interest a great deal of legal professionals have in this matter, specifically in the context of ICC. All over the world, arbitration is on the rise. In 2023, we registered a total of 890 arbitration cases, which was the third highest number of new cases in our history. The ICC Court and ICC Dispute Resolution Services are committed to upholding the highest standards of arbitral integrity while enhancing accessibility and efficiency for businesses worldwide. We are determined to keep making dispute resolution more efficient and more adaptable to the ever-evolving global market demands. As you are going to study and perhaps one day practice arbitration, you are now stepping into a field that is increasingly vital for maintaining international trade, business continuity, peace, stability, and fairness. I am confident that the ICC comprehensive training on arbitration practice will meet your expectation and equip you with the tools you need to succeed. Thank you once again to everyone who has contributed to this initiative. I wish you all the best of luck in your learning journey and look forward to meeting you all, if not in Krakow, in Paris, or elsewhere around the world. Thank you.
Well, after hearing this enlightening presentation, all that I would like to say that we hope to meet one day Secretary General Alexander Vesas here in Krakow. I bet that on behalf of the Dean and Vice Dean and authorities of the Faculty of Law and Administration, we can extend a standing invitation to Secretary General Alexander Vesas to visit us in Krakow and perhaps offer yet another exceptional presentation. We have one evening, but we have actually two distinct keynote addresses today. And the second one will come from Małgorzata Surdek-Janicka, who's a Vice President of the ICC International Court of Arbitration. The subject matter of this presentation is equally important as the very basics of arbitration, the role of ICC. It's all about the party autonomy. Without the party autonomy, there is no arbitration whatsoever. So everybody knows who has learned anything about arbitration that actually parties' autonomy is at the heart of this system. But as one may assume, it also has its borders, its limits, its frontiers, which are, let's say, dynamic. Actually, those limits tell us more about the role of the party autonomy than the general concept of the party autonomy. Before I give the floor to Małgorzata Surdek-Janicka, I would like also to share one thing about this distinct practitioner. Actually, personally, for me, she's a real pride of the Polish arbitration community. Those who know me know well that I'm not a person who likes to flatter a lot. Actually, I'm rather rigid, but this time I can say that I'm always more than impressed when I have the opportunity to hear from Małgorzata Surdek-Janicka. I could speak for an hour about her. This full page is just basic information, but let me tell that before he has become a Vice President of the ICC International Court of Arbitration, he has been on the ICC Court since 2018. First as a court member for Poland, and after that she has been appointed as the Vice President. According to the peers and the clients, she's one of the best international arbitration specialists from Poland, highly competent and professional when conducting proceedings. She's a class act with brief of experience and her own style. These are not my words, these are words of, as I said, peers and clients who were surveyed by Who is Who Legal Chambers and Legal 500. She has been declared as one of the most in-demand arbitrator and persons in the dispute resolution Hall of Fame as a leading individual. In 2021, Forbes Women Poland honored Małgorzatas position in the business world and included her in its list of 25 top female business lawyers and the list of 100 women of year 2021 globally. She's the founder of Surdek Arbitration, international boutique law firm specialized in arbitration. Before she established this law firm, and before she started to practice as independent arbitrator, she was a dispute resolution partner at CMS. She has 25 years of experience in the field as a member of this global international arbitration group. As I said, I could go on and on, but I'm also aware that most of you know very well Małgorzata, and you share my admiration for her. I'm really proud and humbled to welcome you and to give the floor to you right now.
Sir Olesh, for this very flattering introduction. I somehow doubt your fame of being very rigid after what you have just said. Good afternoon, ladies and gentlemen, dear colleagues. Let me start by congratulating Mr. Maciej Janka and Professor Andrzej Olasz and all those who supported them on bringing back a comprehensive training on ICC arbitration to the hospitable setting of Jagiellonian University in Krakow. It has already been proven to be a perfect match, as we heard from the Secretary General, Alexander Kresas. I would also like to express my gratitude to the organizers of this opening ceremony for inviting me to speak about the concept of party autonomy and its limitations in international commercial arbitration. I feel truly honored to have the opportunity to address you on this topic today. Before I delve into the details of the idea of party autonomy, I would like to mention what, quite unexpectedly to me, has become a source of inspiration for me in thinking about this topic. By pure coincidence, while preparing this address, I started reading, more or less at the same time, the most recent book by Professor Timothy Snyder, which was published earlier this month. It is titled On Freedom. As many of you know, Professor Snyder is a historian and a political philosopher from Yale University, specializing in nationalism, history of Central and Eastern Europe, history of the Soviet Union, and the history of Holocaust. I mentioned my reading of his recent book on freedom, as I discovered it helped me to structure my thinking about the concept of party autonomy in international arbitration, or in arbitration more generally. Professor Snyder starts by explaining what freedom is by referring to a distinction between a negative freedom and a positive freedom made by another historian and political philosopher, Isaiah Berlin, in his Cold War time essay on two concepts of liberty. As a side note, I need to mention that I have a very fond and vivid memory of this essay, as it evokes my university times, during which I attended a tutorial led by late Professor Marcin Król, an eminent Polish political philosopher and historian of ideas, whose first assignment given to students at the time was a critical analysis of this Isaiah Berlin's essay on two liberties. So Snyder repeats after Berlin that a negative freedom is a freedom from coercion and oppression by other humans. According to this negative conception of freedom, the wider the scope of activities in which we can do as we please, the freer we are. Of course, we can't all have unlimited negative freedom. The freedom of all needs to be limited to ensure the freedom of all. A positive freedom, in turn, is a freedom to envision the future and have the agency to shape it. Snyder labels freedom as the value of values, or if you wish, the value of the highest order, as it allows individuals to autonomously determine what other values they ought to follow, and allows all those other values to exist and prosper. There are various values worth realizing. However, sometimes it is impossible to reconcile them all at the same time. For example, says Snyder, you cannot be completely honest and completely loyal at the same time. Therefore, people need to make choices between values all the time. And it is an incessant human endeavor to navigate between various goods or various values. I can see a great deal of analogy between Snyder's conceptualization of freedom and its limitations, and the understanding of party autonomy and its limitations as developed in the jurisprudence in international arbitration. It is, of course, trite to say that party autonomy is the cornerstone of international arbitration. We all know this. This is what students of this training course will be repeatedly told over the next couple of months. But what exactly is party autonomy? First and foremost, party autonomy is nothing less but the party's freedom to shape the arbitration process and exercise significant control over it. This is where the analogy with Snyder's conceptualization of freedom comes handy in understanding what the role of party autonomy in international arbitration is. It is its value of values, or the most important foundational value. This is because, and I repeat after Snyder, it allows other values pursued in arbitration to exist and prosper. These other values include flexibility, neutrality, efficiency, privacy, just to name a few. Professor Jan Paulsen, in his well-known book, The Idea of Arbitration, has observed that, and I quote, "The ideal of arbitration is freedom reconciled with law. Acceptance of arbitration is a distinctive feature of free societies and is generally rejected by totalitarian states." Paulsen concluded that the argument in favor of arbitration is based on the premise that people are free to arrange their private affairs as they see fit, provided they do not offend public policy or mandatory law. Party autonomy has many facets. For starters, parties can choose between institutional and ad hoc arbitration. They can also choose legal rules applicable to their dispute, both substantive and procedural, or go as far as to opt for the rules which are not those of a given legal system, for example, lex mercatoria, or the principles of equity. Furthermore, parties can choose arbitrators, the ability which some hail as the highlight of party autonomy. Finally, the parties are free to tailor the arbitral procedure to particular circumstances of their dispute. The parties' freedom to shape the arbitral procedure is recognized and protected by the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which permits refusal to recognize an arbitral award where a tribunal has failed to comply with the parties' agreed arbitral procedures. The extent to which parties can shape arbitral process is best illustrated by a famous quote by Richard Posner, allegedly the most cited legal scholar of all time and retired US federal judge, who wrote in Baravati versus Jokntal, Lyon and Ross as follows. This is one of my favorite quotes, although quite extreme, I would say. Short of authorizing trial by battle or ordeal, or more doubtfully by a panel of three monkeys, parties can stipulate to whatever procedure they want to govern the arbitration of their disputes. This notwithstanding, and like freedom, party autonomy is not absolute or limitless. It has boundaries. Various legal, procedural, and policy considerations can restrict party autonomy in specific contexts. For example, the party's freedom to state the arbitral process as they please is circumscribed by the minimum requirements set out in Article 18 of the Ancestral Model Law, which requires that the parties be afforded equal treatment and a fair opportunity to be heard. Furthermore, parties' right to appoint arbitrators is limited by the requirement that the arbitrator must be impartial and independent of the parties, unless the parties decide to waive this requirement. However, even then, there is a limit on the scope of the permissible waiver, as certain conflict of interest situations are non-waivable. This includes situations deriving from the overriding principle of natural justice that no person can be their own judge. Late Professor Emmanuel Gaillard has noted that while philosophical notions of autonomy and freedom are at the heart of the study of arbitration, similarly essential are the questions of legitimacy raised by the freedom of the parties to favor a private form of dispute resolution over national courts, to choose their judges, to tailor the procedures they deem appropriate, to determine the rules of law that will govern the dispute. From this vantage point, the limits to party autonomy may be perceived as a way to give legitimacy to the arbitral process. The more parties shape the arbitral process to look like proverbial trial by battle or ordeal, or by a panel of three monkeys, the less legitimacy it enjoys. The right balance must therefore be found between promoting flexibility of arbitration on the one hand, and on the other hand, ensuring its integrity as a method of resolving disputes in accordance with the rule of law. Or otherwise, the legitimacy of arbitration will be lost. On a more granular level, that is the one below the meta purpose of legitimacy of arbitration, limitations to party autonomy serve a whole variety of more detailed goals, like safeguarding fundamental principles of natural justice, morality, and public order, such as, for example, equality or the right to be heard, that aim to prevent unfair or biased outcomes. Other limitations connected with the issues of arbitrability aim at reserving certain types of disputes for state courts, because they touch on issues that affect not just the parties involved, but also third parties' interests or broader societal interests. And last but not least, limits to party autonomy are imposed to make sure that arbitral awards are enforced by state courts. So where to look for those limitations? By and large, the limits to party autonomy are set by public policy at the seat of arbitration or at the state of enforcement of an arbitral award. Furthermore, they can be found in mandatory provisions of the applicable law, substantive and procedural. Finally, they stem more and more often from private mandatory rules established by the arbitral institution. Those limitations are the reflection of tensions or even conflicts between party autonomy and certain other values pursued in arbitration. You remember my comment on Snyder's describing the constant human endeavor of navigating between various conflicting values that cannot be all realized and fulfilled in 100% at the same time. So this is what happens in arbitration as well. Therefore, various arbitration stakeholders, including arbitrators, arbitral institutions and state courts face the challenge of reconciling such conflicting values by giving priority to party autonomy at one time or to other values some other time. I would like now to turn to some examples of those conflicts that occasionally arise between party autonomy and certain other values like efficiency of arbitral proceeding, equality in constituting an arbitral tribunal, protection of third-party interests. In this vein, I will discuss first some common tensions that occur practically on a day-to-day basis between parties' freedom to shape the arbitral proceeding on the one hand, and the powers and duties of arbitrators on the other hand. I will next turn to discuss some tensions that appear from time to time between party autonomy and so-called private mandatory rules, by which I mean the rules that arbitral institutions consider so essential to the service they provide that no derogation from those rules is accepted. I will also discuss the controversies surrounding the way arbitral institutions exercise their discretion in performing some of their functions, which sometimes goes as far as to override what the parties have agreed in their arbitration agreements. Finally, tensions may arise between parties and state courts at the post-award stage with respect to the scope of judicial review of arbitral awards. Turning to the first group of conflicting values or tensions between party autonomy and powers and duties of arbitrators, the core question is here whether in the conduct of the proceedings, arbitrators must always follow the parties' wishes, or whether they can ignore them for the sake of, for example, efficiency or other important considerations. This is a very practical question that arises almost daily in arbitration practice. The usual answer to it is that party autonomy must prevail if the parties agreed to a certain procedural step, such as, for example, bifurcation of the proceedings, or to certain procedural timetable, or the manner in which evidence will be taken. However, there is a gray area where there may be situations in which party autonomy and the arbitrator's role collide. This may happen when the parties reach an agreement, but the arbitrators conclude that agreement to be unfair, inefficient, or otherwise inappropriate. Should they use the powers they are vested with to fulfill their procedural duties, or should they be loyal to the parties who provided them with those powers in the first place? In such uncomfortable circumstances, arbitrators find themselves really between a rock and a hard place. Among the various possible problematic situations, we could think of the following: requesting truly unreasonable time extensions, multiplying the number of written submissions beyond what is really reasonable, proposing an exaggerately high number of witnesses, while it is quite evident that the witness examination will not be effective. Although such deadlock situations are rare, when they occur, they trigger the question of which position should prevail. From a practical standpoint, seeking a balance between both positions seems to be the optimal approach. The arbitrator should be cautious in the exercise of their powers and, in principle, use them when the parties cannot reach an agreement. But when there is an agreement, it is hard to imagine a scenario where it would not represent, to some extent at least, an advantage for the parties. The parties are arguably the best to judge whether a solution that they propose serves their needs or not. Even when such an advantage may not be crystal clear or self-evident, prima facie, their opinion should command some deference. Therefore, the arbitral tribunal should be cautious before it seeks to impose a rule at variance to that agreed upon by the parties. In deciding whether to make such an order, the tribunal should carefully consider the reasons underlying the parties' agreement, and only in really extreme situations try using its powers to limit party autonomy. Let me now turn to controversies surrounding arbitral institutions' incursions into the territory of party autonomy, or to what Professor Klaus-Peter Berger calls a party autonomy paradox. Professor Berger points out that, and I quote, while party autonomy can be freely exercised in choosing an arbitral institution and its rules, that choice may have a price in the form of limitations on that autonomy when it comes to the conduct of the proceedings under the chosen rules. By way of reminder, the arbitral model law reflects the vital link between the institutional arbitration and party autonomy. Article 2b of the model law provides, where a provision of this law leaves the parties free to determine a certain issue, such freedom includes the right of the parties to authorize a third party, including an institution, to make that determination. The fact that the parties, by choosing a specific arbitral institution, vest this institution with the performance of numerous tasks during the arbitration leads to two very important questions. First, are the parties bound by this institution's arbitration rules to the extent that they are considered mandatory by the arbitral institution? And second question, does the arbitral institution, in exercising the administrative discretion granted to it under its rules, have the power to overrule a procedural agreement by the parties? Replying to the first question about the parties' freedom to derogate from the rules that an arbitral institution considers to be mandatory, the outcome will be quite predictable, I think. The institution will simply refuse to administer the parties' arbitration. The ICC court, for example, would most certainly refuse to administer an arbitration in which the parties have agreed to opt out of the terms of reference procedure or the confirmation of arbitrators nominated by parties by the Secretary General, or of scrutiny of draft arbitral awards by the ICC court. All of them being distinctive features of ICC arbitration, not found in the rules of other major international arbitral institutions. This supervisory role of arbitral institutions is a natural consequence of a service contract concluded between the parties and the institution. If the institution is liable to the parties under the contract for a proper administration of the proceedings according to its rules, then the institution has a legitimate right to make sure that the parties do not evade those core provisions of its rules, which the institution considers essential for arbitrations conducted under its auspices. The arbitral institution's refusal to administer the arbitration has a considerable limiting effect on the parties' autonomy. However, that limitation itself is based on the parties' presumed will. When agreeing to arbitration under the rules of a given arbitral institution, parties are assumed to have accepted the mandatory rules contained in the arbitration rules as restrictions on their general autonomy to tailor the proceedings in the way they please. Consequently, if a party is faced with the institution's refusal to administer the arbitration, decide not to terminate the arbitration, but to continue the proceedings without the administering services of that institution, the nature of the arbitration changes from institutional to ad hoc. In line with this view, the parties to ICC arbitration who had opted out of the ICC court's core prerogative under the ICC arbitration rules to confirm arbitrators nominated by the parties and to scrutinize the final award before it is served on the parties, decided to continue their arbitration as ad hoc proceedings and conferred on the ICC court the power to act as appointing authority when the ICC court declined to administer their arbitration. The limits on party autonomy set by the institution's refusal to administer the arbitration do not frustrate the parties' general intention to have their dispute resolved outside of the domestic courts, but only their choice as to how that alternative dispute resolution process is to be conducted. Turning to the second question about whether the arbitral institution's discretion in exercising its powers under the rules, can override parties' joint will enshrined in their arbitration agreement. The best illustration of this process problem is the arbitral institution's power exercised in the context of expedited arbitrations, where institutions often determine that the case will be decided by a sole arbitrator, even if the arbitration agreement provides for 3 arbitrators. The conflict between the discretionary power of the institution and the parties' arbitration agreements has been resolved so far differently by different courts. For example, the Singapore High Court did not regard the existence of the party agreement on a 3-member tribunal alone as an absolute bar to the appointment of a sole arbitrator by the SIAC president. This is because the 1-member tribunal was a fallback rule provided for in the SIAC rules, Article 5.2b, thereby indicating a strong preference of this institution for that option in the interest of procedural efficiency. However, another court, the Shanghai Court, seized with the enforcement application, considered the aspects of procedural efficiency, even if enshrined in the institutional fallback rule, to be unable to trump the autonomy of the parties. In view of the significance of this judgment by the Shanghai Court and its reference to the primacy of party autonomy, the SIAC in 2016 addressed this question, and now the SIAC rules stipulate by agreeing to arbitration under these rules, the parties agree that the rules and procedures set forth in Rule 5.2 shall apply even in cases where the arbitration agreement contains contrary terms. The ICC arbitration rules adopted a similar approach. Article 30, Section 1 of the ICC rules states that by agreeing to arbitration under the rules, the parties agree that this Article 30 and the expedited procedure rules shall take precedence over any contrary terms of the arbitration agreement. More specifically, Article 2, Section 1 of Appendix 6 to the ICC arbitration rules provides that the ICC court may, notwithstanding any contrary provision of the arbitration agreement, appoint a sole arbitrator. That solution is indeed a remarkable outcome, given that it leads, at least in Professor Berger's view, to the unique and paradoxical situation that the parties, by referring to the SIAC rules or the ICC rules, specifically agree to invalidate their own agreements, insofar as they are contrary to the expedited procedure provisions within those rules. It is noteworthy that some other institutions have taken a different pro-autonomy approach to the resolution of the conflict between implementing the will of the parties and the need for procedural efficiency in expedited proceedings. By way of example, Article 41, Section 2 of the Hong Kong International Arbitration Center's rules provides that if the case is to be conducted pursuant to the expedited provisions, the case shall be referred to a sole arbitrator unless the arbitration agreement provides for 3 arbitrators. And if the arbitration agreement provides for 3 arbitrators, Hong Kong International Arbitration Center shall invite the parties to agree to refer the case to a sole arbitrator. However, if the parties do not agree, the case shall be referred to 3 arbitrators. A similar approach has been adopted in Article 42, Section 2 of the Swiss rules. Yet another dimension of arbitral institutions' discretion in exercising their functions, which at the same time limits the parties' rights to choose arbitrators, has been sanctioned by courts, at least French courts, in the well-known Dutco case and most recently in the Didatel case. In the latter case, 2 partners holding 25% stake in their joint venture included in the shareholders' agreement an arbitration clause, providing for an ICC arbitration seated in Paris. Pursuant to the arbitration agreement, the dispute was to be decided before a panel of 5 arbitrators, one to be designated by each out of 4 shareholders. And the 5th arbitrator was to be designated by the other 4 arbitrators, provided, however, that no agreement between the arbitrators designated by the parties is reached. The independent or the 5th arbitrator shall be designated by the president of the ICC. One of the shareholders who sued its 3 remaining partners proposed that the arbitral tribunal should be composed of 3 arbitrators instead of 5, because of the convergence of interest between the other 3 shareholders. It reasoned that appointing 5 arbitrators would result in the tribunal being constituted by a majority of arbitrators appointed by parties whose interests would be aligned against claimants, which would be against the principle of equality. Therefore, claimant appointed 1 arbitrator and requested the other 3 respondents to propose 1 arbitrator jointly. However, the other 3 respondents rejected this proposal and each appointed 1 arbitrator as per the arbitration agreement. And they said, well, the equality rule is preserved because each shareholder has an equal right to appoint 1 arbitrator. Considering the disagreement between the parties, the ICC invited the parties to agree on a different method of constituting the arbitral tribunal, but was unsuccessful. Therefore, the ICC court dismissed the parties' nominations and appointed all 5 tribunal members under Article 12.8 of the ICC arbitration rules. Subsequently, the ICC court dismissed a disqualification application against the 5 arbitrators it had appointed. The respondents who lost this arbitration subsequently tried to set the award aside for it having been rendered by improperly constituted arbitral tribunal. The French Cour d'appel dismissed this objection, stating that the principle of equality between the parties is not only to be assessed at the time of the conclusion of the arbitration agreement, so at the time when each had an equal right to appoint 1 arbitrator, but also on the day the dispute had arisen, taking into account the claims and interests of each of the parties. Subsequently, the French Cour de Cassation, the French Supreme Court, which dismissed the appeal against this Court of Appeals judgment, held that since all the disputing parties were deprived of the right to choose their arbitrator, the equality between them was preserved. In the limited time that I have, I will not elaborate on the 3rd group of conflicts between party autonomy to shape the scope of judicial review of the arbitral awards and other values considered to be part of the public policy at the seat of arbitration. Just to only mark this problematic, the key question here is to what extent the parties can modify the review of the award made by the national courts at the seat of the arbitration. Some parties may wish to exclude entirely the possibility to seek a set-aside at the seat, contractually, of course. Alternatively, the parties may wish to limit the review by national courts at the set-aside stage by specifically excluding or implicitly waiving certain grounds. And there's also a 3rd option. Parties may sometimes desire to have an extended review by the national courts at the seat. There are significant differences in the approach to this conflict between values in various jurisdictions. The differing views in this area may be attributable to the different assessment of the competing public policies at play. For instance, in some jurisdictions, for example, Switzerland, set-aside waivers are only open to non-local parties, having no link with the seat. France, in turn, allows full set-aside waivers, but refuses to enforce partial waivers. While the US Supreme Court in the Whole Street case determined that the parties' agreements for expanded review, judicial review of an arbitral award, was unenforceable. Just a year earlier, so in 2007, the German Supreme Court reached the opposite result and reversed its prior case law in this respect. So completely different approaches, completely different outcomes. Clearly, the policy of protecting third parties and public interest as opposed to parties' interests only at the post-award stage is an important concern for national courts. In conclusion, I would like to say that a discussion on party autonomy and its limitations never ends, given that arbitration laws and arbitration rules constantly evolve. While the primacy of party autonomy, which, to borrow from my early remark on Snyder, is the value of values pursued in arbitration, is a well-established concept. The question of where its limits are is not always clear, not finally set in scholarly writings or state court decisions. I wish the participants of the upcoming ICC comprehensive training very many fascinating and thought-provoking discussions on this and other topics. Thank you very much.
Well, so as I suppose, I'm left speechless after hearing this presentation. It wasn't just enriching; it was actually mind-blowing for me. So one will see that it wasn't just exaggeration to say that the quality of lawyering and oral skills of Małgorzata Surdewiak-Niemska is absolutely world class. So it was nothing about flattering. It was just truth. Thank you very much. And while I was hearing to this absolutely tremendous presentation, it came to my mind that I have committed one serious faux pas. More than one, but this is something that I would like to mention. Today we have here also another great women lawyer who was so kind as to come and accept our invitation, although it was really on a short notice. I'm talking about Dr. Małgorzata Kozłów, who's with us, who's a part of our faculty, the chair of the European law. And I feel like she really requires mentioning as I'm also always very impressed by the quality of her skills and presentation. Dr. Kozłów is also very active in the field of mediation. She's responsible for the Jagiellonian University moot court or moot mediation teams who are very successful in this very important moot courts. So I would like to thank her for accepting our invitation and being here. She contributes greatly to making true this phrase that Jagiellonian University is not only past, present, but also the future of teaching and research in Poland. Thanks to such great scholars. Okay, but now it's time for a coffee break. And before we'll go to the coffee break, I would like to extend my warm thanks to the sponsors of the reception, but also of the coffee break. If I don't do it now, I will forget then. Yes, indeed, I would like to thank a lot to two leading Polish law firms who are active also in the field of the dispute resolution, including international arbitration, and I mean GP Partners and KKG, Kubaskos, Gałkowski. Actually, today we have the founder and managing partner of GP Partners, Maciej Gawroński, with us. I'm very glad that he has found the time to come here, along with a senior partner, Piotr Riematowski, who also some kindness to come up and visit us today. So truly, it's a great pleasure to have you with us. Unfortunately, Dr. Rafał Kos, who's a senior partner in KPMG, couldn't appear because of his other duties, but I would like to personally mention him as he's always ready to support anything that we do here at the Jagiellonian University without any hesitation. He's always ready to come up and support us. Actually, I can convey this my gratitude via my dear friend, Dr. Maciej Lukas, who will join us after the break, the coffee break. He's a co-leader of the arbitration practice at KKG and also a trainer of the Jagiellonian University Wismut team. Another person that I highly admire, I have in a high esteem. My former friend at the Wismut team more than a decade ago. Now he's a trainer for more than a decade. Oh, he's there, yes. Maciej Lukas. So I have a great pleasure and a great timing to mention Maciej just as he arrives. Okay, so thank you a lot for the first part of our inaugural conference. I invite you warmly to our coffee break, and then we'll continue with a panel of rising stars in international arbitration led by our great colleagues. Thank you very much, and enjoy a coffee break.
Welcome to the break. I know that in the end of the coffee break is the most important part of the event. Also, we would like to come back to the very discussion. As you know, our course is titled ICC Comprehensive Training on Arbitration Practice. Therefore, practice is the essence of that. Well, if we are talking about practice, we are thinking who is at the scene of our course. Naturally, there are young lawyers. And naturally, young lawyers think, why I need this course for? Will I have a career in arbitration? And this is the reason why we established the next panel. The next panel will have the title, Same Road, Different Paths, How to Develop Career in International Arbitration. The moderator of this panel is Justyna Szpara. Justyna is Vice President of ICC Arbitration Commission. She is also Vice President of the ICC Poland and the President or Chair of the Arbitration Commission of ICC Poland. Justyna is established arbitrator and accomplished arbitrator on the Polish arbitration scene. She is also honorary member, what is important for this discussion, of the International Association of Young Lawyers. She is honorary member of that organization. Justyna, floor is yours.
Thank you very much, Maciej. Let me only mention that being an honorary member of the International Young Lawyer Association, not doctor, so that. But, ladies and gentlemen, it's for me a true pleasure and honor to be here. And let me start with congratulating Maciej Janka and Professor Olasz for putting together this wonderful ICC comprehensive training, but also this opening ceremony today. As Maciej mentioned, the whole course, the whole training is designed for younger generation of lawyers. And when Maciej approached me with an invitation to be part of this opening ceremony and to give an address to the potential and future participants of the course, I thought that I actually will give you something better than this, that I will give you a true perspective to what it takes
to develop a career in international arbitration. And for that purpose, I have invited 3 exceptional panelists, the true rising stars of arbitration, international arbitration practice. So let me start the introduction with a lady, Monica Hill. Monica is a counsel with Clifford Jones, and Monica, she came to Kraków from Frankfurt because she is sharing her professional time between Warsaw and Frankfurt, Clifford Jones. Monica has many years of experience representing clients in complex litigation and arbitration disputes, which span in a variety of sectors, including energy, construction, real estate, TMT, and finance. Monica also regularly acts as a counsel in investment treaty arbitrations in the CED region. Monica is recognized as arbitration future leader by Hughes School Legal. She is a co-chair of DILOS Y and of the European subcommittee of the Campaign for German Arbitrations, which I think is a great initiative. Since recently, Monica is also a Polish delegate to the ICC Commission on Arbitration and ER, and she graduated from the leadership program at the Stanford Graduate School. So she's really a well-placed to be here this evening to explain about career in international arbitration. To her right, Maciej Gurwas. I think Maciej was already mentioned today at this opening ceremony. Maciej is a partner and co-leader of arbitration practice at Kubas Kozłowski, based here in Kraków. Maciej is undoubtedly the dispute resolution expert with experience as an arbitrator, as counsel, as a tribunal secretary, and his focus is in the construction dispute, post-M&A dispute, rolling stock in life science sector. Maciej publishes on international arbitration. He is also frequently a speaker on dispute resolution matters on arbitration conferences. Maciej is also a member of arbitration committee at the Court of Arbitration, and similar to Monica, he is recognized in several rankings, whose legal expert guides transfers. Last but not least, Maciej is a coach of the Jagiellonian University Maltese. Last but not least, Tomasz Cyron, my third panelist. Tomasz is an advocate, an arbitrator, mediator, and academic teacher. Tomasz is for years now a member of the Chartered Institute of Arbitrators, and for several years an officer of the Mediation Committee of the International Bar Association. So his practice covers both arbitration and mediation, and I think that mediation is also his very dear topic. So I hope he will give us also some perspective of this aspect of alternative dispute resolution mechanism. Tomasz is very active as an arbitrator. He has experience in proceedings under ICC, LCIA, VIAC, or leading Polish arbitration institutions rules, and he's a co-author of commentary on the provisions of civil code of proceedings relating mediation. So the topic of today's panel refers to the career goals. And I believe the long-term career goals of every arbitration practitioner are pretty much the same. We all want to work as counsel on international cases, and we all wish for appointments in large international matters as arbitrators. But I think that each of us had a very different starting points. For me, arbitration was not a first choice in my arbitration career. So it was not my dream to become an arbitrator or even arbitration counsel. And it was a matter of one case which actually brought me into the world of international arbitration. So the question to my panelists, what was the starting or maybe pivotal point in your career in arbitration? What was this entry point for you?
Thank you very much, Justina. I will take the first question, and thank you for having me here. As you mentioned, straight from Frankfurt. So my first choice was also not arbitration. It was international relations. So I started to study international relations at the Warsaw University first. And then together with a group of friends, we decided that we need something more concrete. So we applied to law school and decided to simultaneously study both subjects. And we graduated as a group, and actually majority of these people work as lawyers rather than diplomats. So I think it also carries some meaning. But as I was working my way through law school, I always was looking for some ways for it to be more international and to combine the two topics. And that's how I found my way to moot courts, where I actually met Maciej about like 12 years ago. So I participated in the international commercial arbitration moot court, the biggest one, the Wismut, and then the foreign direct investment moot court. And for the first one, Jagiellonian University always prevailed, whereas for the second one, hopefully Warsaw University also had some success. So that brought about opportunities with international law firms for internships in Warsaw, and that's how I started when I was still a student. And it allowed me to do real life arbitration investment cases. Already as soon as I started, we worked on a case against Poland, so it was a super exciting opportunity. And I stayed, and nowadays I also, after these 12 years, managed to make it to the international world, and I work a lot on cases that don't even relate to Poland that much, hence the Frankfurt part. But it was not always that easy. And I think the one point that I would like to share with you all today and to have in the back of your heads for this as you pursue through this course is that I had the privilege to have amazing mentors, especially female lawyers who are very established in the arbitration world that helped me navigate my career. And that's something that I really want you to all to think about as well. That sometimes it's just not enough to do what you think is good enough, but also to try to find someone that could help you and guide you throughout the process. So that's essentially the both starting and pivotal parts for me.
Excellent. Jennifer, how about you, Maciej?
Thank you, and thank you very much for having me. And indeed, I share this starting point with Monica because it was also a moot court competition, Wismut, that actually introduced me to the world of international arbitration. Before that, I wanted to be a criminal lawyer, and actually 15 years ago, it's 15 years ago in October when I was recruited to the Wismut team, and this is when the international arbitration appealed to me, and I will come back to this appealing element, and I started to work in a team representing Jagiellonian University, and then I remained as a coach. And it's a great opportunity. It's great if you do something extra apart from the standard curriculum. Wismut teaches you how to write, how to argue a case. It teaches advocacy. It teaches you legal research, which is sometimes overlooked at Polish universities. And this is an amazing set of skills that will stay with you irrespective of whether you prevail in competition. But let me share some negative aspects of the competition. Well, it gives you false impressions because Wismut, as most of you probably know, requires you to become a counsel in a major very difficult international arbitration case. And then you go to Vienna or Hong Kong and argue this case before leading arbitration lawyers, the authors of the books you're reading, and people that are partners that are leading international departments of law firms. And then you have false impression that when you start your actual work in September or October, you will be doing precisely that. Well, no, you won't. You will have to work hard, and everyone, each of us, I assume, worked hard to start their career. So this is, I think, a moment when your expectations about this appealing world of international arbitration and the hard reality of everyday work clash. But to sum up, I think that moot courts are great ways to start, and most of the people I know that actually took part in the competition from Jagiellon University, including Professor Olasz, for instance, well, they don't regret it, and they definitely their skills ameliorated, and their position, their careers is better.
It's exciting, but I'm very glad, Maciej, that you did not pursue your career as criminal lawyer. We are very happy to take you as an arbitration practitioner. Just to follow up on that, my first choice was tax law. Thomas, what was your first choice?
Well, I don't know what my first choice was, but I had like a completely different beginning than my colleagues. When I was doing Erasmus, when I was in Germany, I took a course called Kommunikationstechnik und Juristen, so communication techniques for lawyers. So I was focused on communication, on talking, on meeting, on connecting people, not on, let's say, on merits of the disputes. So after I graduated university, I focused on mediation. I did postgraduate studies. I was really great fan of negotiation, so I was saving money and asking my parents for help, and they sent me to Boston to spend some time at Harvard to participate in the Harvard negotiation project courses. And that was my, let's say, my main plan, to do something that no one, or maybe not no one, but it's still not common in Poland. And arbitration was not something worse for me. It was like top notch. I thought, I'm smart, I can achieve a lot, but arbitration is still much above my abilities. And when I was, of course, I participated during my bar training, during Applicacja, in the first edition of Leviathan Moot Court, but I was focused once again on mediation plus standard daily routine of applicant, so normal cases, average cases in village, car, surrounding towns. And I remember when I did one course on arbitration, but I kept it for later, but I knew only the theory. And I remember my obrona, so the final exam of my PhD, and one of the members of the commission was Professor Elżbieta Traple, who was not only the professor of civil law, but he was the president of the local arbitration court here in Kraków. And after my exam, I asked her in the kindest way I could, Madam, Miss Professor, I was wondering if I could ask you if I could, and so on and so on. Then I said, if there are any options to become arbitrator, and said, oh, Mr. Till, after I heard your presentation, it's obvious that I'd like to have some arbitrators in court as you are. Just contact my secretary tomorrow. And I was wondering if she's really serious about it, just kind of saying, like, call my assistant. They called the assistant next day, and then it said, yeah, Miss Professor already said that you'll be calling. Bring the papers in your phone and roll to the list. I was really happy and lucky that I got my first examination really fast, quickly, and the chair of my panel was Piotr Nowacek, who is really experienced arbitrator, and he was really great teacher, because he explained everything to me, and the other arbitrator was freshman as well, what he's doing, why he's doing. And then I got further nominations, and the first the time I was the chair, my co-arbitrator was Justyna,
who was really great supporter, and again, great teacher, great coach, because it was obvious that the co-arbitrator was much smarter, much more experienced than the juror. But we managed it together to win the case, and that's how we went. And then it went on and on. But still, I guess I have more mediations than arbitration cases. But it shows that you can be a lawyer, successful and happy and satisfied lawyer, without need of going to court to the public court every single day.
Point that you can be a happy lawyer. It's important, well, interesting to hear that each of you have a slightly different career path. And so I see already from our presentations that this career path differs a lot. International firm, large domestic firm for Maciej, or smaller practice for Tomasz. What do you see as the advantages and disadvantages of each of these options?
If I may answer this question by picking up Tomasz's last point about the first case, and coming back to the maybe less appealing reality. So my first case, arbitral case, was as an arbitrator. He was presiding arbitrator, and one of the partners of law firm from Warsaw called me and said, "Listen, I remember you from Wismut. You were, doing arbitration. I think you're okay, and we have a case. And how about you take a role as a chair?" I was taken aback. Of course, I accepted it. It turned out that it was a case for a couple €1,000, but the party's request were 3 pages long. It was a very complicated case, default proceedings, not participating respondent. Well, I learned probably a couple of gray hair working on that case. So it was a very, very difficult case, especially that, it's the first case, you want to impress everyone, etc. And of course, those bigger cases will come with time. And it also relates to your question about the reality of work. Well, I've been only a trainee in a major law firm. I haven't worked in a major international large law firm, because after the Wismut I got an internship in KKG law firm, and I stayed there. But the impression is that you're a part of a bigger team and you have a specific tasks to do. So before you will reach a role that is important, that is your dream to be the first chair in the proceedings, Monica is smiling, so I believe that I'm not that's wrong.
That would be challenging though.
So it takes time. The smaller the law firm, the bigger chances that you will have a chance to actually shine and actually become an important part of the team. So was I wrong with the big law firms and the role?
You were a bit wrong. But I guess the impression that you have comes from mainly like major jurisdictions like London or Paris, where I see and I know a lot of people who work there who actually are more, like, as Maciej mentioned, like dedicated to specific tasks before they are able to see the entire case or argue it. And I remember when I did my first cross-examination at a major hearing some years ago, and this partner from London approached me after and said, "You have to realize that you're very privileged to be able to do that, because in London that would never happen, because, in London you always, do just a bit of a case, and then either the barrister even from the outside comes and argues the case for you." So I think we are kind of in between the, super big impression international law firm because we are here. So I think it helps us, and actually for our team, even though it was a super international law firm, when I started, the team was not that big. So it was like 10, 12 lawyers. So it was just impossible for the partners or, London partners to handle everything. So it came quite fast for me to do a lot of responsible things. So I guess it depends on the team, and that's something you also have to realize, that you may face a situation where for a number of years you will, just be one of the associates working on a major case, but there are international teams where you can already, as a quite junior person, have a lot of responsibility. So I guess that's a bit relative. But I do think that the work that you can do internationally is of course challenging and demanding and requires a lot of resilience, but it's also rewarding because especially that's kind of what I wanted when I studied international relations, to be able to work on cases that actually impact the international law. So when it happens, when you're able to work on a case like that, it's rewarding enough to overcome all the struggles of working in a big law firm. And if I may just touch on another kind of disadvantage, not to disagree with you on everything. From the arbitrator's perspective, it's much more difficult because of the conflicts, right? So that's the difference, but that comes later. So I do see a lot of people as they get senior, they simply leave at some point because the conflicts are just impossible and it's difficult to get arbitral appointments, unlike in a bigger domestic law firm.
You can see that it's actually kind of advantage to be an international arbitration lawyer in Poland.
I will always say that.
Thomas, is it an advantage to be international arbitration lawyer in Poland?
It's a hard work. I've been not in a big international firm, neither in a big Polish firm. I had to do everything myself, and I am doing everything myself. There are some few so-called boutique law firms in field of arbitration, but they are mostly established, opened by people who were partners in big law firms, and then we created something new. Here, my of course, I'm far from those boutique law firms, but I had to establish everything and do it step by step. Recently, one of Polish leading arbitration lawyers who established a year ago, 2 years ago, his boutique, was asked, how is it to run a small firm? I said, I have a lot of technical issues and duties. And the interviewer asked him, but I believe you don't buy the paper to print yourself, don't you? And said, no, that'd be too much. And I'm doing it myself. So that brings a lot. It demands a lot, but on the other hand, it has advantages. First of all, freedom. When I always hear from senior advocates that being advocate is being free man. And I do whatever I want. I don't, probably my yearly salary is similar to the money, it's not salary, the money I earn is similar to what Monica earns in a quarter. But again, I'm free, I do whatever I want. I don't have any conflicts. Because if I thought now I work with two bar trainees, I'm sure that they haven't been involved in a case which I'm doing. Plus something which is not common in Poland, and probably lawyers of my age, around 40, I'm only one who's here, Marek Kowalski, who does the same. We are able, what I did, frankly, first time in my life this summer, but I was asked by my client to play golf with him during the weekday. And we went on Tuesday to spend the whole day playing golf, and it was much more fun than sitting over the laptop and reading the file. So being serious now going to the point. If you are independent, you have a lot of additional responsibilities. You don't get some cases which you would have in a big law firm because you are not credible enough. Even if someone knows you, he says, okay, but my clients, my partners, they don't know you. So these are the disadvantages and lack of money, lower amount of money you receive. But I do whatever I want, and that makes me, once again, happy and satisfied lawyer.
Actually, as a former tax lawyer, I'll tell you that in some jurisdictions, Greenpeace are actually tax deductible. Coming back to the training, opening of which we are now celebrating. Well, my panelists today have one more thing in common. They all are still currently participating in ICC Advanced Arbitration Academy for Central and Eastern Europe. And I wanted to ask
what is your takeout from the academy? Was it worth it to participate in this kind of journey?
It was definitely worth it, but we also have another thing in common. We are, I think, all happy lawyers, right? Defending, like different paths, but still happy. About the academy, I think it's it's this, we call it amongst ourselves, like a course, advanced course in arbitration for aspiring arbitrators or junior arbitrators, so to say. So people who already are appointed, but not that much experienced yet. And for us, it's focusing on Eastern Europe. So it gave us the opportunity to network with our peers from all over the region. So not only Poland, but a lot of people from Romania, the Balkans, the Baltics, Hungary, Czech Republic, and many other countries. And it really is a great knowledge sharing and experience sharing platform. I think it hasn't ended yet. We still have one course to do, but the course is planned in a way that we meet every couple of months throughout the year in a different city in Eastern Europe. And then we, of course, work on a case together. But I think even though it hasn't ended yet, we already see a lot of benefits from this networking, like, possible appointments or the ability to refer a case to a lawyer we are familiar with abroad, or recommendations for looking for experts or legal advice. So for the networking part, and I know Maciej is going to talk more about the content, that's really an amazing thing to do. So I would encourage anyone who is eligible to apply for it with a sufficient number of years of experience to definitely do that.
I agree with Monica on everything she said about the networking part and the entourage with the academy. I think from the substantive perspective, it's also very worth it. The course is based on one arbitration proceedings, a very complex multi-party disputes, and we entered the dispute as arbitrators in the initial part, so we have to make a disclosure, make our statement, and then we finish with an award, which, by the way, I haven't prepared it. So it's great because it's it allows you to get hands-on experience on a major case, and also ICC case, which is very peculiar in some aspects, especially the initial phases as to the appointments of arbitrators. So I definitely learned a lot. And combining that with the networking aspect, well, I believe it's great to exchange views on one issue with our colleagues from various jurisdictions. And finally, it might be a bit of a spoiler, but the courses, I believe that the tutor's perspective is also to prepare us for the worst. So we often face challenges that would be very challenging in classic arbitration, like a person appealing during hearing, third party, or default proceedings, recording of hearing surfacing on YouTube. What do we do? Well, I think if we've done all the test cases we've been doing during last month, we will be prepared for everything as arbitrators. So definitely.
Not the first time when ICC course is hosted by the Legal University. Some years ago, there has already been ICC training at this university, and Tomasz, you have participated in this course at that time.
Yes, I first of all, I agree with everything what Monica and Maciej said about the advanced arbitration academy, which we attend together. And what happened here about 10 years ago, I'm not sure if I can say that the same course, the similar course was held, although it was organized by ICC, and Mr. Degenicka, Mr. Jamka, Mr. Sinashpana, they were teachers, coaches here, and I was listening to them. knowing at the beginning nothing about arbitration. I was not sure whether award is a judgment or like an extra judgment, because award is like a prize. I was not sure if challenge is a challenge or not, but I was doing it step by step. I was not hoping to become, as I said, arbitrator. I just wanted to know something about it. But I learned a lot, and then when I got the first cases, I had some kind of background, some issues that first sound strange and sound, let's say, quite standard, and then were familiar. I think that those who are decided to join this course, you did a really great step in your career. You don't know what you'll be doing in the future, because most of you are like final year students or junior layers. Maybe you join a big international firm, maybe big Polish local firm, maybe a small firm, maybe you do something about arbitration, maybe not. But even if you'll be like an average, boring advocate or radca prawny, you'll be doing like standard cases. But once you may not say, oh, and how about arbitration? I have like a special knowledge, and it's something that is really useful and is great. So if I were you, I would do the same. I mean, if I would be like 10 years younger, I'd do the same and join the course with you. So I think that's a great opportunity to learn about arbitration and network. So my tip to you is to take as much as possible from your trainers, and I wish you all the best.
So for those who did not register yet, if you want to be like Tomasz or Monika or Maciej, register now. It's worth it. Thank you very much, and wish you all the best for everything.
Ladies and gentlemen, this panel concludes our today's meeting, our official ceremony of the opening of our course. I would like us to make one announcement, which is very important in the light of what we have heard during this panel. I would like to assure you that in this room, there are not only young lawyers who are happy, senior lawyers are also happy about what they are doing, and I'm definitely an example of that.
What else to add? That was a definition of a lively discussion, so I think that it's a great moment to conclude, to thank all of you as appeared today, and to wish those who have already registered a really great experience, enriching experience, which will add to their future careers, whatever they will do, whether it will be arbitration, just as Tomasz said, or anything else. We were quite sure that this journey will be a great part of your curriculum and your future careers. So yes, we can say that the official part of our inaugural conference is concluded, and now we can start the second part, which is a reception, as I already said, sponsored by KPG law firm and GP Partners. So let's meet upstairs, the reception rooms of this great place, and have some fun. Thank you very much.